The first point which should be led by freshly enrolled advocate and aspirant of advocate on record exam is the jurisdiction. Jurisdiction is the first point to learn in litigation, which should be learned by freshly enrolled advocate and the aspirant advocate on record exam. Reason is that it is not only important from any point of view, but it is most essential knowledge to have for lawyering or practicing in court also. In fact, this term is not defined in any statute. And when any statute or any term is not defined in a statute, then one has to look either into dictionary meaning or the meaning that is ascertained by the Supreme Court in our country. It is always better to look into the ascertained meaning by the Supreme Court, because the Supreme Court must have gone through all such exercises for ascertaining the meaning or the interpretation of the expression. And this is the Supreme Court is the apex court in the hierarchy of the judiciary of the country according to the Constitution. And you must be knowing that the law laid down by the Supreme Court under Article 141 of the Constitution has to be abided by all the courts and the tribunals in India. The first and foremost decision the Supreme Court in its decision, that is namely Ujjambai versus State of Uttar Pradesh. AIA citation is All India Reports 1963 Supreme Court, page 162. And citation in the Supreme Court report says 1962 SCR, volume 1, page 778. And it was decided on 28th April 1961. The Supreme Court ascertained the meaning of the jurisdiction. Let me quote the words of the Supreme Court in the said decision with regard to the jurisdiction. Quote, "It is necessary first to clarify concept of jurisdiction. Jurisdiction means authority to decide." Now another aspect is how to understand about the term authority and authority to decide, and in reference to the aforesaid decision. It is not difficult. Authority means potency or power, and authority to decide means potency or power to determine. What is to decide specifically in reference to the jurisdiction? That is, to decide specifically in reference to the jurisdiction means to inquire into a question for the purpose of giving decision over it. And in reference to the court or tribunal, it is the potency or the capacity or power conferred by the law on the court to inquire any question of law or any question of fact for the purpose of giving a decision on it. And whenever a judicial and quasi-judicial authority or tribunal is empowered or required to inquire into a question of law or fact for the purpose of giving a decision on it, it is said that such court or tribunal has jurisdiction. But how to understand the authority to decide? That is to say, how jurisdiction has been given or conferred upon any court or tribunal. That is the legal term for giving or investing jurisdiction, means the conferring. But when you have to find it out, how to know what is to understand by the authority to decide, it is the language, phrases or words used that is indicated in the jurisdiction has been conferred. For example, if you see the section 9 of the Code of Civil Procedure or the sections of the Code of Criminal Procedure, and then example for aspirants of advocate on record, they must see Article 131 of the Constitution of India. If we see section 9 of the Civil Procedure Code, then we will find the phraseology, the clear-cut conferring the jurisdiction. The section 9 says, part 1, suits in general, jurisdiction of the courts and res judicata. Section 9, courts to try all civil suits unless barred. Now the attention, the court shall, within bracket, subject to provisions herein contained, have jurisdiction to try all suits of civil nature. See the phraseology. The court shall have jurisdiction to try all suits of civil nature. This phraseology clear-cut says that the jurisdiction has been conferred by Section 9 over the civil court. Similarly, you see Article 131 of the Constitution of India, where the original jurisdiction has been conferred upon the Supreme Court by the Constitution. Now see the phraseology used in this article. Subject to provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute, etc., etc. So here are the clear-cut words of conferring jurisdiction upon the Supreme Court by the Constitution. Words are Supreme Court shall, to the exclusion of any other court, have original jurisdiction. Now another example where there is no clear-cut words of conferring jurisdiction on the court. This example may be seen in Article 71 of the Constitution, where you will have to decipher the words or the phrases used in the language of the Article 71. Now let me read to you Article 71. Article 71, Clause 1. All doubts and disputes arising out of or in connection with the election of President or Vice President shall be inquired into and decided by the Supreme Court, whose decisions shall be final. You may perceive, you may find that here is the words that the dispute, all doubt and disputes arising out of so and so shall be inquired into and decided. These three phraseology says that the Supreme Court shall have jurisdiction to decide the disputes related to the president election or vice president election. So there is some difference of the words maybe. I had already told you that it is the language, phrases or the words employed in the law that will show that how the jurisdiction has been conferred. So this is another example of knowing that jurisdiction has been conferred upon the Supreme Court by the Constitution in the matter of deciding doubts and disputes. And not only this, the power has also been perceived by the another phraseology, whose decision shall be final, which means the Supreme Court has power to have its order or its judgment or decision enforced. It has power. So all these three functions, authority to decide a jurisdiction, and the power is implicit in the language or the phraseology of the Article 71. Yes. Jurisdiction may be the pecuniary jurisdiction. Jurisdiction may be the subject matter jurisdiction. Jurisdiction may be the territorial jurisdiction. It may be according to the subject or the special situations where is the jurisdiction can be understood. And in this regard, you may see the original jurisdiction, appellate jurisdiction, revisional jurisdiction, special jurisdiction, so many other jurisdiction. So you have to see what kind of the jurisdiction is being dealt by you when you have to either file the any pleading or the matter. Then you have to first point to see what kind of the jurisdiction is involved in the matter which you are going to file. Or if you are responding to the matter, then you have to see whether the jurisdiction is implicit or involved or expressly conferred in the matter filed by any other person. If not, then you have to take one objection over it. So points of jurisdiction has to play its either in the favor of the party or against the party. So whenever you respond to any matter, then you have to oppose that there is no jurisdiction with the court. In this regard, there are so many jurisdiction can be pursued. Now, it's not only the jurisdiction. Certain other similar kinds of the words you have to understand. For example, jurisdictional error, jurisdictional facts, jurisdictional area, jurisdictional field, and all other allied terminology with regard to the jurisdiction. But most important of these two is the jurisdictional error and jurisdictional facts. These two aspects have to be taken into consideration before you proceed to the filing of the matter or before you proceed to contest the matter. The jurisdictional error, you may find it in section 115 of the Code of Civil Procedure, where you will find that the section says that the court has failed to exercise jurisdiction which was vested in it, and the court does not exercise jurisdiction when it was vested by the law, or it has exceeded its jurisdiction and committed illegality. So these are the jurisdictional errors under section 150 of the Code of Civil Procedure. Next video we will tell you what is the jurisdictional error and what are the jurisdictional facts. Both are important for the purpose of contesting the case or filing the matter in the court.